Let's say you're driving through Iowa. Cornfields on both sides, cruise control set, music low. Then you see it, red and blue lights in the mirror. This is where most people mess up. Not because they're criminals, but because they talk too much. Today, we're breaking down exactly what your rights are in an Iowa traffic stop, what you legally must provide, what you don't, and how officers can use your words to extend the stop, escalate it, or justify a search. This isn't anti-law enforcement. This is pro-rights. In Iowa, during a lawful traffic stop, you are required to provide your driver's license, proof of registration, proof of insurance. That's it. You do not have to answer investigative questions, explain where you're going, explain where you're coming from, consent to searches. You can simply say, "I'm not answering questions." That is 100% lawful in Iowa. Yes, if an officer orders you to step out of the vehicle, Iowa follows federal law. The U.S. Supreme Court ruled in Pennsylvania v. Mins that officers may order a driver out of the car during a traffic stop for officer safety. You don't argue. You comply physically, not verbally. But compliance does not mean consent. Yes, and this matters. Once you exit the vehicle, roll the windows up, lock the doors. Why? Because if the car is sealed, it prevents claims like, "I smelled marijuana." Odor claims are subjective, unprovable, and commonly used to justify searches. Locking your vehicle protects you without saying a word. Yes, if you are lawfully detained, you must stand or sit where the officer directs. This does not mean you've waived your rights, you've consented to anything. It simply means you are complying with a lawful command while preserving your legal position. This is one of the most important questions you can ask. Ask clearly, am I being detained or am I free to go? Why? Because a traffic stop is temporary and tied to its original purpose, the traffic violation. Once the reason for the stop is complete, continued detention requires R.A.S. R.A.S stands for Reasonable Articulable Suspicion. Here's the key point most people don't understand. Right arrow, the traffic violation itself is R.A.S for the stop, but not for prolonging the stop. In Iowa, officers may not extend a stop beyond its original purpose unless they can articulate new R.A.S. This principle is supported by Rodriguez v. United States. Iowa courts have followed this standard repeatedly. If an officer starts fishing, asking unrelated questions, delaying for AK-9, or pushing consent, you should ask, "What is your R.A.S for continuing this detention?" You are not being rude. You are forcing legal clarity. Iowa courts have consistently held that a stop may not be extended without independent R.A.S. Silence is not suspicious. Refusal to consent is not suspicion. Cases like State v. Powell's reinforce that detention must be justified, not assumed. Police are trained to gather evidence. They are not there to help you beat a ticket. Your words are evidence. Silence is protection. Comply physically. Assert verbally. Document everything afterward. If this helped you, hit the like button, subscribe, turn on the notification bell. And if you want deep dive breakdowns of real police encounters, court rulings, and body cam analysis, check out Audit the Audit, Long Island Audit, Lackluster, The Civil Rights Attorney. Some of the best channels out there, just to name a few. Stay calm. Stay respectful. Know your rights.